Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been a rare filing from defense counsel Jay Logsdon, who has not been very involved in the case for the past couple of months, and who the public learned a while back will not be participating as defense counsel at trial. But on the 22nd of May, in a newly released document, Mr. Logsdon filed a motion to permit mitigation witnesses to watch trial. And essentially what this motion is for is seeking an order. That's what a motion is. It's an application for a court order authorizing mitigation witnesses for any sentencing phase in the event there is a conviction to watch the guilt phase of the proceedings, which is the first trial and possibly maybe the only trial if there is a return of a verdict of not guilty. This document states that comes now Brian C. Kohberger by and through his attorneys of record, and hereby moves this court to amend its exclusion orders in this case to permit mitigation phase witnesses to watch the trial. This motion is based on the fact that the evidentiary rules do not apply to the mitigation phase, as this court has previously ruled. Additionally, the purpose of the exclusion of witnesses rule does not apply to the mitigation phase. Mr. Logsdon then cites Rule 615 of the Idaho Rules of Evidence and states it governs exclusion of witnesses. It reads, quote, "At a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own," end quote. Then defense argues the purpose of IRE 615 is to allow courts to prevent witnesses from shaping their testimony to conform to or rebut the prior testimony of other witnesses, and then citing an appellate court ruling from 2008, State versus Huntsman. The vital importance of sequestering witnesses is recognized as a foundational element of due process in American jurisprudence. And then Mr. Logsdon cites two U.S. Supreme Court case, Gators versus United States from 1976. In the mitigation phase, however, the witnesses are not true fact witnesses as in the guilt phase. They are not intended to provide accounts of events that are disputed, and thus the concern for tailoring their testimony does not exist. While it is unclear that the mitigation witnesses will want to watch any part of the trial, there is no reason to penalize them if they do. This court is therefore requested to amend its earlier exclusion-related orders to permit them to watch the trial. Dated the 22nd of May, 2025, Jay Logsdon, 1st District Public Defender. So what Mr. Logsdon is saying is, look, if this were other guilt phase witnesses, if they were intended to provide testimony during the guilt or the case in chief phase, that would be one thing. Mr. Logsdon is arguing they're not. They are only going to be providing testimony during the penalty phase, if there is one. Now, who are these witnesses? We don't know, because all witness lists are under seal. That was a directive that Judge Stephen J. Hippler entered in the order of October 9th, 2024. You can find that directive on unnumbered page 3 as it relates to guilt phase, and also lay witnesses. All are under seal. We will now await a ruling from the court to determine if this motion will or will not be granted, and when that is rendered, we will advise you of what the court's ruling is on this matter. This will now conclude this episode of the Indie Zone. Thank you very much for joining us today.